Hi, I'm attorney Julie Hauf, and today I want to talk about a situation that we don't see all the time, but one that we definitely need to be prepared to deal with on the PIP side, both when you are making claims payment decisions and also when you're handling that litigation. So first of all, what do you do when you have Florida bills for an out-of-state policy? Well, the first thing you need to do is get right in there and look at that policy and see what kind of coverage you have. Do you have language in your policy that says pay them the way someone in that geographic area where that accident happened would get paid? If you have that, then you've got to go back and look at the Florida statute and pay like that. If you don't have that, go ahead and pay pursuant to the policy. Your policy might have a we will not pay more than, or we will pay the lesser of what their normal cost is, what the fee schedule would be, or whatever other contract there might be in place with that particular provider. So look at that to make sure you're paying it the right way. Second of all, how much were you supposed to cover? Do you have an out-of-state policy with only $1,000 of NPC, MedPay limits? If that's the case, check your policy for language that says that you get the coverage if there is some default coverage where the state is happening, where the accident happened, where the treatment happened. Check and see if your policy actually allows for more coverage than you would have ordinarily expected under that state-issued policies declarations page. But what happens most importantly when you're in litigation with an out-of-state policy? Well, we're going to handle it the same way we normally would, of course, but there's 3 extra questions that I think are really important that you want to make sure you cover here. The first is there anything in that insurance contract which says which state's law applies to disputes? Almost always you're going to find that the home state's law applies to disputes. Why is this so important? Well, first of all, as you might be aware, in Florida, we have an attorney fee provision in our Florida PIP statute. Other states don't necessarily have that at all, or the fees are only allowed if there's been some kind of bad faith. So you may not have an automatic right to attorney's fees if that particular state's law applies. So that's one of the first things we always look at when we have an out-of-state policy come in. The other thing we always take a look for is to see if that state's law has a different statute of limitations for either breach of contract actions or actions that are brought under the particular kind of coverage that's sought to be applied here. So for example, there are some places that say all suits have to be initiated within 1 year of the start of treatment. There are some states that have a much shorter statute of limitations for breach of contract cases than Florida, which has 5 years. We have had several cases get resolved on the fact that, well, there's no attorney's fees here, so you can even make a different payment decision and all you will owe the other side is the benefits, the interest, and their filing fees, which might be about $100, the other cost of litigations, issuance of the summons, and service on you, but not what can be a really driving factor, the attorney's fees. We've also had some files that have resolved because the claim is brought, that suit is brought, even though it's in Florida, outside of the statute of limitations of the controlling state's law. So those are really important things that you want to go look for as you're adjusting a claim, but also as you are defending a claim for a PIP suit on an out-of-state insurance contract. We're happy to answer questions on this and all other areas involving PIP and BI law. You can contact us. My cell is 239-218-3297. We're always happy to help, and you know where to find us. Thanks so much. Have a great day.